Jenny, you can start the recording whenever you want, and I will. Okay. Hello, everyone. So my name is Tatsuma Padoan. I'm a lecturer in East Asian religions in the Study of Religious Department at UCC. And today I'm very glad to welcome our guest speaker, Dr. Natalie Ghosn. Dr. Natalie Ghosn teaches at Acadia University and Mount St. Vincent University in Nova Scotia, Canada. She obtained her PhD in International Relations and International Political Economy from the University of Miami in 2019 with a dissertation on comparative religious law. She is also a fully licensed attorney in the state of Florida. Her area of academic focus is comparative international law, but she has also done research on public and private law, humanitarian law and human rights, comparative politics and international relations, political economy and foreign policy, public health, gender justice, and international development. Today, she will present her research on religions and law, alternative dispute resolution in Islamic and Judaic law, case studies of Canada and the US. Thank you very much, Natalie, for being here, and the floor is yours.
Thank you. I'm very pleased to be addressing the University of Cork, College Cork today and sharing some of my doctoral research and findings with you. So as was mentioned, I come from a very strong background in international law as well as in family law. And over the years, I have noticed that considerations of religion and belief systems in general seem to be a factor in many of the cases, but were often ignored in much of social science research where their consideration would have added value, probably on account of the difficulty of quantifying religious factors. The significance of belief systems on law became even more apparent to me as my PhD studies progressed. And I eventually took a turn into left field away from very positivist studies of international law, international relations, and international political economy into religious studies and anthropology. So thus, the study that I conducted that I'm going to present to you today very much embodies the spirit of interdisciplinary studies, overlapping in a number of academic fields, including gender studies, anthropology, religious studies, and comparative law. There's a lot of literature out there on religious arbitration or the use of religious law in state court proceedings. However, there has not been much of an exploration of community-based law. That is, law that occurs at the community level, often inside a house of worship, such as a synagogue or a mosque, where disputes are resolved at the community level without recourse to state or provincial apparatus. The relationship between secular and religious practices of clergy members in our present society became a focus of my work. The study I conducted looked at these internal processes and employed a variety of methods. Ethnography was one of these. From an academic point of view, it does have its limitations, but also allows for answers to the sort of questions posed by this study that would otherwise be unreachable. So a little bit about the project itself. This project, which, as mentioned, was the basis of my doctoral dissertation, had a number of goals. First was to develop an understanding of the methods by which Jewish and Muslim religious leaders engage domestic conflict matters through a religious lens and in a religious setting. Secondly, to understand how religious leaders think about a variety of topics related to law, dispute resolution, the family, and gender, and how religious leaders engage these topics on a practical level through the pastoral care that they give. And lastly, to understand how religious leaders understand their reality and see their own place in society. This study had several major findings, and I will describe shortly how I came to these conclusions. First, mediation through pastoral care serves a useful social function. Creating a system of broader education for those in pastoral care roles will assist in avoiding potential ills informal forms of mediation can have on women or other disempowered members of society. Religious leaders assist in the integration of newly arrived immigrants, and religious leaders understand their unique position in society and often embrace this role through the consideration of secular laws and secular values in the pastoral care they give. So to engage this inquiry, I asked a number of research questions, and both the qualitative and quantitative findings of those questions I will share momentarily. The first research question of this study asked, from the perspective of religious leaders, do religiously affiliated individuals feel obligated to pursue a religious resolution to family law conflicts they are facing? 2, how effective is pastoral care as a form of alternative dispute resolution? 3, what shape and form does community-based, non-state sanctioned practice of religious law take in North America? And 4, what are the gender implications of the community-based, non-state sanctioned practice of religious law in North America? In terms of the case studies for this project, there were 2 religions, 4 denominations, and 2 states studied. In terms of Islam, both just Sunni Islam and Sharia law was studied. And in terms of Judaism, Orthodox, Conservative, and Reform Judaism and their relationship to halakha, roughly translated as Jewish law, was studied. Personally, I conducted over 93 lengthy ethnographic style interviews of rabbis and imams, roughly evenly distributed between the 4 denominations. There were 26 Sunni imams, 23 Reform rabbis, 22 conservative rabbis, and 22 Orthodox rabbis that were interviewed and participated in this study. In terms of methodology, the study took a bottom-up approach, drawing on larger conclusions from the individual responses of the religious leadership from the intensive IRB certified interviews. I'm not sure if you have the same system in Ireland, but we go through a number of courses on ethical training and interviewing before we're able to conduct these sorts of studies. And all of these interviews were personally conducted throughout Canada and the United States by me. There were qualitative methods used in terms of the ethnographic style interviews, and there was also quantitative data generated from a variety of yes and no questions. I'm going to share some of the visual images with you shortly of the results of that data. The first major inquiry of this project examined religious obligation and legal issues. It asked, is an individual, religiously observant or otherwise, required by their faith to pursue a religious resolution to a crisis they are facing? This inquiry found that religious leadership is often able to employ congruencies between secular and religious law in the advice and opinions they give as part of their pastoral care. However, in terms of Judaism, denominational differences in Judaism played a significant role in determining the priority halakha has in an individual's everyday life. So let me do the share screen with you now so I can show you how some of these results turned out in terms of data. It's loading, so just give me a moment. Okay, so hopefully everyone can see this graph in front of them. So this image got at the heart of whether religiously observant individuals, from the perspective of religious leaders, felt that you had to first turn to your faith for dispute resolution. So it also touched on the idea of whether or not the faith traditions themselves felt that their religion was all-encompassing, meaning, could the faith tradition provide the required mechanism and answers to a variety of crises an individual could face in their lives? So we see here significant differences in the denominations. Let me share another image with you. So this image represents whether or not religious leaders have deferred to secular state law when conducting a mediation or religious counseling session with a parishioner. Here, I didn't see any significant difference between Orthodox and conservative Judaism, and which may not necessarily be intuitive at first, but in Sunni Islam, there was a very high prevalence of imams who directed to state law, not religious law, in their pastoral care when they felt that an issue presented to them was outside their area of expertise. The second major inquiry of this study addressed alternative dispute resolution in the religious communities studied. This part of my project sought to determine how effective pastoral care is as a form of alternative dispute resolution. In this inquiry, I found that mediation through pastoral care serves a useful societal function and fills a void for religiously observant individuals who may not take or may be unable to take necessary steps in their secular realm to address a crisis they are facing. Religious leaders felt that oftentimes knowledge from sources outside the faith were useful in addressing crises brought before them. So this is the visual depiction of that inquiry. So here again, we see that there was a very high prevalence of religious leadership actually considering secular law in the community-based alternative dispute resolution they were conducting. Sometimes this occurred more formally with one or multiple experts of the faith being convened on a particular issue, and other times this occurred less formally in the form of pastoral care of a single dispute, such as a dissolution of marriage, for example. The third inquiry of this study sought to elicit the shape and form that the non-state sanctioned practice of religious law in North America takes. There were a number of findings here. There is significant recognition of and adherence to secular law by religious authorities. Religious leaders felt a dual responsibility in both the religious and secular realms. The religious setting did not preclude women's participation, and crises were approached on a case-by-case basis, so there was no rigid set of standard rules applied to these sessions. So this is an example of that consideration. And so we see here the percentage of religious leaders that felt personally obligated to ensure that a civil marriage certificate was filed for each religious ceremony they conducted. There were really a variety of reasons why this compulsion was felt. Some sought to curtail polygamy, for example. Of course, from the perspective of the state, this remains a major issue in terms of social service administration or determining survivor rights in states where common law marriage is not recognized, like Florida, for example. There are also gender concerns, which my next section addresses, as to the women's ability to seek recourse to a state court in an instance of dissolution of marriage where no official legal marriage has been registered. This is also one of the underlying reasons by which the state itself empowered religious leaders to conduct marriage ceremonies in the first instance. This image depicts what percentage of religious leaders in each denomination believed that they were actually required by their faith to adhere to the civil marriage requirement of the state. So for example, in Judaism, it is a pretty well-known tenet that the law of the land is the law. And thus complying with religious law also meant complying with the civil marriage requirements of the state. Where the answer was in the negative, which was a very few instances, it was usually on account of a religious interpretation that felt as though God was the only one an individual should be held accountable to. This was a minority perspective. In some outliner cases, there was also a secular reason given, like allowing younger couples to register their marriages after they turned 25 so they could remain on their parents' health insurance plans. Of course, this sort of reasoning was only relevant in the United States and not in Canada. The final major inquiry of this project was about the gender implications of the community-based, non-state sanctioned practice of religious law. There were several main findings. First, religious precepts are rarely enforced. Matrilineity discriminates against men, and culture was blamed for gender discrimination towards women. This image depicts whether or not, from the religious leader's perspective, same-sex marriage is permitted in the faith. Graphing was a little simplistic for this question with regard to the Jewish denominations, as in conservative and reform Judaism, it was left up to the individual rabbi to determine whether or not they would perform a same-sex marriage ceremony, as opposed to an overarching mandate that the marriage ceremonies must or must not be performed. In terms of Sunni Islam, we see here that 100% of respondents stated that same-sex marriage was prohibited, but most added the caveat that a homosexual person could not, under the authority of the religious leader, be turned away from a house of worship. Another sort of interesting facet of the Judaism side of this question was when I interviewed rabbis, sometimes in the same synagogue or the same religious school, they would have offices next to each other, and one would perform same-sex marriages and one would not perform same-sex marriages. So that's a very solidified belief in the conservative and reform traditions, that it's left up to the individual rabbi to decide for themselves whether or not they will perform these marriages. So this is a visual depiction of the question that asked. It is sometimes said that in your faith, men are superior to women in matters of legality. Do you think there is a reasonable foundation to this belief? This was a question out of the 48 questions that were asked during this interview that generated the largest discrepancies in terms of responses within denominations. Every faith tradition acknowledged, to one extent or the other, the reality of male superiority in the faith, whether in terms of marriage and divorce rights, inheritance, or a number of other topics. However, whether or not this reality was reasonable elicited a number of different responses. Some simply blamed the role of culture and religion, while others justified this reality based on the differing responsibilities of men versus women in society, and the creation of a male-led system of social services, and so on and so forth. Another issue where I saw a lot of denominational discrepancy was on the issue of interfaith marriage. In the Sunni Islamic tradition, interfaith marriage is permitted only for men to women of the Abrahamic faiths, so the question was not applicable to this group. We can see large discrepancies between the Reform and conservative denominations, for example, from general acceptance to absolute prohibition. So just to wrap things up, we have a lot of time for questions. This study had several major findings, which I can elaborate on during the question and answer period. Mediation through pastoral care serves a useful social function. Creating a system of broader education for those in pastoral care roles will assist in avoiding potential ills informal forms of mediation can have on women and other disempowered members of society. Religious leaders assist in the integration of newly arrived immigrants. Religious leaders understand their unique position in society and often embrace this role through the consideration of secular laws and secular values in the pastoral care they give. While ethnography has its limits, it has allowed me to reach insights that would not otherwise be reachable. Based on the findings of this study, a strategy of integration should be pursued between religious and secular institutions. Instead of religious leaders referring congregants in crises to outside sources, religious leaders should have access to resources to address a wide variety of subjects. Developing a system of broader education that includes training for religious leaders in social work, counseling, law, and other relevant fields that is cohesive with secular standards would create a system that would be beneficial for society in addressing crises of congregants that are of a secular and/or faith-based nature. It is clear that religious leaders who resolve disputes ultimately serve a role in shaping the community, no differently than judges in any society. Access to a broader system of education for religious leaders would be a positive contribution to society. Religious leaders often act as a buffer between the less integrated members of religious communities and newly arrived immigrants to their religious communities and broader society. Clerics themselves understand their unique position in society and often embrace this role through the consideration of secular laws and secular values in the pastoral care they give. They provide an educational function to congregants of a non-religious nature. And to end on an optimistic note, overall, I found that religious leaders act as interlocutors, and this study suggests that as part of immigrant integration, they can be won over as partners rather than antagonists. Thank you. So I'm happy to take any questions anyone has.
Thank you very much. I wish to thank you for this interesting presentation and project explained. Actually opens, I'm sure, many directions for discussion. So before opening discussion to the public, I would like just to make a short comment and one question. Well, the comment is that I really welcome your approach integrating ethnography and law and study of law. I think even if I'm not an expert in law, the fact that you could find through ethnographic method new ways of understanding, perhaps from the ground, the kind of legal problems we're investigating seems quite promising. And you also mentioned anthropology. So my question is about the method, the ethnographic method. Whether, for example, you have done participant observation in this settlement of disputes, family disputes, or private arbitration in the religious context, or whether the kind of interviews perhaps you were conducting, whether they were structured, unstructured, semi-structured, so something about the method. And lastly, whether you also had a chance to interview members and practitioners other than the leaders, perhaps members who were involved in this private cases of arbitration, or also people not involved from the community, what they thought about the whole process.
So I'll start with your last inquiry first. So in terms of this study, the scope was limited to religious leaders, and the specific reason for that was that I was trying to find the individual that was in the role of adjudicator, or in the role of a magistrate, in the role of a judge. So this was the comparative perspective that I was specifically looking at in this study. But I'll tell you, the entire way through this study, I had thought, a perfect avenue for future research on this topic would be to look to really be able to interview or examine the individuals that participated in this dispute resolution. And one area that I thought would be very interesting would be to see how many of these, because we're talking about family law disputes, how many of these couples and partnerships really settled on the decision of the religious leader, and how many of them then ended up in a state secular court for the same issue. I thought that would be a very interesting area of future research. Now, from the perspective of the participants in the dispute resolution. Now, from the perspective of the religious leaders, I actually did ask that question. And, there's no way for them to know with absolute certainty, but I asked them, when you give your opinion, you give your decision to a couple, like how often do you think that they follow this? Or if they don't like your answer, do they simply just go off to the state court where they're entitled to go after they've gone through this sort of informal dispute resolution with you? And almost all of my respondents, from my recollection, said that they felt that their parishioners really heeded their advice and really followed, what they, sort of what they had given in terms of a resolution to their problem. So it would be something interesting to follow up on. The second part of your question was about methods, right?
Yep.
So for this particular study, I did not do participant observation. What I did was simply an interview style. And I did have a structure. So I had 43 questions that I used as a guide that I followed. For the most part, they went in order, but depending on, the responses of the religious leader, there would be follow-up questions in between. So it was semi-structured, and the questions were open-ended to an extent that I wanted the individual to feel that I was interviewing to feel comfortable, to feel that I wasn't there to interrogate them. Because, the dynamics of, especially, the last several years in the United States, the dynamics of religious leaders in these particular faith traditions in the United States is they are always on the defensive. They are constantly being attacked in the media. They very much have the perception that if someone from outside their community is coming to ask them questions, it's to accuse them of something. So that was a barrier that I had to get over in my research. And at first, it was actually quite difficult to get interviews. And part of the reason why I left the questions open-ended was to allow them to feel comfortable in being able to answer and give me the information they wanted to give me. So I didn't cut them off when they were speaking. And some of my interviews lasted 2.5 hours because of that. You know, there were several very lengthy interviews, and started with very basic questions about, you know, their background, you know, what was their calling to religious leadership, you know, how did they, you know, find themselves on this path. And that also elicited a lot of really interesting information, especially in Sunni Islam, where many of the imams were engineers, doctors, or came from a completely different career path, which was very interesting, and then had a calling in religious leadership. So it was simply interview style. And then I did the snowball approach. So I was put in touch with a few religious leaders in my network through personal introduction. And as the idea caught on that I'm not here, you know, from a journalist perspective or to take a specific opinion on the issue, I'm here really from an academic, neutral point of view where I don't pass judgment on your responses. I really just want to learn this information for the purposes of this research. Once that idea caught on, by the time I actually finished my interviewing in late 2018, early 2019, there were actually people requesting interviews to be a part of this study. And, you know, because for time constraints, I actually had to cut that off. But, you know, I found that the snowball approach worked really well. Was there another part of your question right at the beginning?
Yeah, there was no. You responded to all the questions. Whether you had done participant observation and what kind of interviews.
Yeah.
No, thank you. It was fascinating, and I also agree with you about the idea of further developing your research in the direction of including also the participants, other members involved besides leaders. Also, because sometimes leaders may give a more top-down interpretation of events, a bit more normative, rather than so because of the nature of being leader of a religious group. So also to have a wider perspective on these issues. I fully agree that further research might go in that direction, and would be very interesting. So I open to the floor, and whether there are any questions to Natalie from the public. You can raise your hand, write on the chat, and then write or also speak directly using the microphone. Well, meanwhile, I also had another question. And this relates to religious leaders, because somehow this dynamic you described seemed to me a sort of let's say structure of authority based on tradition, as see in comparison with the authority based on bureaucracy. So I'm thinking in Weberian terms about forms of traditional authority vis-a-vis forms of bureaucratic authority of the state. But then, as you interview the religious leaders, there's a third form of authority outlined by Max Weber, which is a charismatic authority. So I wonder whether you in your research, especially from the ethnographic side, you noticed that some of the leaders were actually charismatic, were displaying signs of charisma with their followers, and how their particular kind of authority was played out in these dynamics.
So one thing that I noticed in the very beginning part of my interview was essentially background information on the religious leader. So getting to know the religious leader and how they came to that position of authority. And I found that there was really a wide variety of paths. Some were very formal, some were informal, and some did have charismatic tendencies, as much as I could tell from a single interview. Some of my interviews were done in person, and some of them were done by telephone. So, you know, there was some differentiation there in what I was able to gauge from the other person. And because I didn't participate in participant observation, I wasn't inside these congregations, you know, I wasn't really able to observe the behavior of the religious leaders in other settings besides the interview setting. So I'm not sure that I have a full answer to that question, but I would say that in certain denominations of Judaism, particularly in conservative Judaism, there's a very regimented track going through, you know, formal theological training and theological school to become, to be in a position of a religious leader in that faith tradition. And often that training included some secular training, like secular counseling methods that would be employed during pastoral care. At the same time, there have been religious leaders in the Sunni Islam tradition, for example, that were simply a community elder who had extensive knowledge of the faith. So, you know, there's very different trajectories to being in these leadership positions. But I think that's as far as I can comment, because I wasn't in a position to observe, you know, those other characteristics, at least as part of this study.
Yeah, no, it's interesting. Also, because if some of the leaders were also displaying forms of charismatic leadership, this might relate also to the problem of power, to question of power within the group, and whether and what kind of power dynamics of power were also unfolded, played out between the leader and the followers during this arbitration processes. Did you notice any particular?
There's one particular dynamic that I thought was really very interesting. So when I went into this inquiry initially, I said, I'm looking for the person in the religious setting that takes the place of a judge, of an adjudicator, of a magistrate, but in the informal sense. So I'm here, I want to make the distinction that I'm not talking about a formal arbitration panel that employs religious law, because we do have those set up in certain parts of North America. I'm talking very much about the community-based level of dispute resolution that's very informal. It's just happening inside an office, inside a synagogue or a mosque or a religious center. Now, some of the religious leaders, because I did ask them, I said, you know, how is your office set up? You know, where do you sit? Where do your parishioners sit? Like, what is that dynamic that's happening? Some had it set up very much like a court. You know, they were sitting behind their desk and the parishioners were sitting in front. Others have made a very conscious effort. There was one particular reform institution in Miami that I remember very specifically that says that they never sit at a desk when someone comes in for dispute resolution. They sit in a circle and they sit on couches. So they want to sort of show that this is a non-confrontational process. You know, court inherently, the way a court is set up, it is set up as a confrontational process. And there's a lot of research that suggests that once you're put in that setting, you're going to elicit very different information than you would elicit in an informal setting, because you're worried that what you say is somehow going to be used against you in the proceedings. So they purposely and intentionally set up, you know, this sort of, you know, bright lights, light paint color, couches, and circular patterns for these meetings to show that this is an alternative to a formal court system. This is, it is informal, but in a beneficial way, that we're here to try to solve this problem, not to add to or exasperate a confrontation that's already occurring between the parties. So it seemed that the religious leaders were very aware of how they wanted their space to be set up, and it was set up in that way. It didn't seem like it was something unconscious that was happening. You know, one of the conclusions of this research is that, you know, over and over again in the interviews, the religious leaders really understood the position that they were in and the contribution that they make to these individuals' lives and the authority that they have. And they sort of exerted that authority in the way that they saw was best suited to their parishioners.
Thank you. Yeah, you replied in an exhaustive way. Thank you. And we have a question from Aman. Aman, would you like to ask you using the microphone? or yourself, or we like, well,
I have some interference. Can you hear me?
Yep.
I wanted to actually ask you, Natalie, when you were doing your research, how did you understand the response of the religious leaders in terms of how they resolved these issues? Did you feel that they were maybe trying to resolve? I mean, was a resolution? Would you see this as their resolution different in terms of the aim than what you would see, as a lawyer yourself working, in Miami? Would that have been different? Do religious leaders try to resolve things rather than, see them deteriorate, if that makes sense? I hope that. And then I was also thinking, what did you learn? I mean, you have such an interesting CV in terms of what you do as a lawyer. What did you learn in terms of Islamic law and Jewish law? Because I think for me, how would you compare that? How would you translate that for someone? Because at a certain level, we think of religion as something that can't compare, or do we really want to see Islamic law as something, or Jewish law as something that resolves things? There was a question in there, Natalie. Thanks.
Okay, so to your first question, I actually found the process to be really different. So what I saw this process unfolding of was more of a mediation as opposed to a court style system. So as I mentioned before, the court style system is confrontational, it's adjudicative, and each individual has, in most instances, a personal representative, an advocate specifically assigned to them that doesn't care about the other side, but that zealously employs legal tactics to the benefit of their client only. In a mediation, you have a neutral third party, or same with an arbitration, you have a neutral third party attempting to recognize the claims of either side and resolve a dispute in a way that is both fair and beneficial to both parties. And this is more of what I saw in terms of the pastoral care and that informal alternative dispute resolution that happened inside houses of worship. I'm not saying there are not instances, because I'm not able to really, observe all these adjudications that happened. But for the most part, the way that it was described to me from the perspective of the religious leaders is this unfolded more as a mediation where instead of taking sides, this individual attempted to, find the best solution, which wasn't always a reconciliation. In some cases, they recommended the separation or the divorce of the couple, but to find the solution that was the most beneficial to both sides. So I saw it more in terms of a mediation, what you would see in that sort of setting, as opposed to a formal court setting. Hopefully that answered your first question. As to the second question, this is a massive question. So what did I learn? So one of the debates that I had when I first started this inquiry, because I didn't come from a religious studies background, I came mostly from a legal background. So when I first started this inquiry and I proposed this idea to a number of scholars, I said, this is something a research that I'm really interested in. We're going to look at religious law and these, faith traditions. And I'll never forget that the first criticism I got is, there's no such thing as religious law. What is religious law? I got this very philosophical response from a religious studies scholar. And I said, oh, it's right here. This is religious law. We look at halakha, we look at we open it up, we read it. There's rules, there's codes, there's exceptions to the rules that were derived. So from a lawyer's perspective, the way that we view Islamic and Judaic law, I think, is sometimes very different from individuals that study in a different paradigm or a different field of social sciences. So that was the first obstacle that I had to overcome when I was doing this research, was first convincing people that there was comparative aspects between these two types of law, and then with state law, which, we understand as being secular, but, really derives from a number of sources. So for me, I found that when you look at this from a legal perspective, that it's very comparative, because you're seeing issues, marriage, divorce, child custody, alimony. This is how we view issues. We go to state law of Florida or the provincial law of Nova Scotia. We go to Islamic law of one of the particular schools. We go to one of the denominations of Judaism, and we get the same thing. We get the rules, we get the codes. We have, a history of how has this issue been resolved in this tradition? How is it likely to resolve in this tradition? We have documents that are akin to divorce decrees. We have ketubas. We have documents that are akin to prenuptial agreements. So for me, of course, we're not getting it. This is not an exact science. We're not getting an exact comparison between these traditions. But from the legal perspective, I have always been able to find comparative aspects between these sort of religious traditions and secular law. So it came very naturally to me. I hope that answered a bit of your question as well.
Thank you.
Thank you. Thanks, Natalie.
Thank you. Are there any other questions? Yeah, I can see Konak.
Yeah, I'll just turn on my camera so you can see me. This was really interesting, and it's not an area I know a whole lot about. And I'm not sure if you talked about this because my internet kept cutting out, but when you were talking about interfaith marriage, particularly with like the Orthodox and conservative Judaism and how that's kind of prohibited, did you come across any maybe like cases where there was interfaith arbitration or where one partner was from either like Judaism or Islam?
So in this particular study, I didn't have any individuals talking about marriages between Islam and Judaism. I had I came across one case in Islam where they discussed the obstacles of interfaith marriage between a Hindu individual and a Muslim individual. The boy was Muslim, the girl was Hindu, and the imam was essentially against the marriage. This was one of the outliner, cases. And, that got into the discussion of who an individual is permitted and not permitted to marry in Islam. So I came across one case like that. In conservative Judaism, I came across a case where interfaith marriage would not be performed by the rabbi. And actually, there were several rabbis that mentioned this to me when we discussed the issue of interfaith marriage and same-sex marriage, that they would not perform interfaith marriages, but they would perform same-sex marriages if both of the individuals were Jewish. So that was also a very common theme. And, the sort of crisis over interfaith marriage in Judaism is a very prevalent, I'm not sure there, but it's a very prevalent debate in the United States where maintaining numbers in that community has been and continues to be, a major concern. So it was interesting to see that the resistance in that community was towards the interfaith marriage and not towards same-sex marriage. So because I was looking at this study through the perspective of religious leaders and not from the perspective of the individuals that, engage in some sort of alternative dispute resolution or pastoral care with a religious leader, I didn't have exposure to too many cases, only the ones that really came out in the responses from the religious leaders themselves. But yeah, those were the instances that I came across in this particular study.
Thank you.
Thank you. And other questions? Are there any other questions? Okay. Somehow your study seems to suggest more interaction between secular law and private religious arbitration. So more interaction, more communication, a certain degree of mutual collaboration would be beneficial. I mean, from in social terms and also according to in juridical terms. I wonder whether, given the presence in North America of so many also Christian sects, but also new religious movements, whether perhaps this form of collaboration or integration would be applicable, in your view, also to other religious traditions, apart from Islam and Jewish tradition, whether you would see something more like more integrated system across different religious traditions, and in combination with, I mean, in conversation with law.
So, from my perspective, most religions have some form of a religious code, maybe not a code book, but within the faith tradition themselves, certain legal rules and precepts have been derived from those traditions. I think that the study in general could be adapted to interviews of religious leadership in other faith traditions very easily, because I think that many faith traditions face the same crises. Now, in the United States, because there's a Judeo-Christian derivation of the law that already exists, the common law that already exists in the United States and Canada, there hasn't been as much controversy or as much tension between those groups and the law. Now, where you do see that is you see that these groups tend to work within the state system itself. So you see cases going to the Supreme Court on abortion. You see cases going to the Supreme Court on same-sex marriage. A lot of these arguments are based on religious grounds. So I have found that a lot of these communities are able to elevate their issues through the state apparatus itself, all the way to the Supreme Court of the United States, for example. So we've seen many issues in that regard, being religious issues, and those denominations in that regard being addressed at the very highest state level within that system itself. Because I haven't studied in the communities themselves, I can't speak to that, but I can say, from just the general legal perspective in the United States, I've seen that these groups have been able to maneuver the state system itself. Now, in terms of the integration, I do really believe that these religious leaders understand their important role, and many of them even welcome the idea of having additional training in things such as social work, counseling, or law. They were very careful to refer parishioners to those resources when they felt that they were faced with an issue that they couldn't address themselves. And they often had a very elaborate network of individuals that they worked with. For example, they may have a counselor that also happens to be Jewish, so has some cultural competence in dealing with a specific issue of a Jewish parishioner. But they also really welcome the ability to have the resources and the tools they need in-house to address, a wide variety of issues. The big issue in North America with that is there's a monopoly over legal services that's held by lawyers in North America. There's this idea of being prosecuted for the so-called unauthorized practice of law, that is giving advice without a valid license to practice law in North America. And this has been a huge debate in the legal community, but it's been very internal. It hasn't been publicized a lot in the media. So people that sit on committees or that are involved in their local and national bar associations, when they go to these meetings, they'll see that one of the major debates that's coming up is, we have a monopoly on legal services. The threshold for low-income individuals to reach legal aid is too low. And the threshold for individuals to be able to afford private legal services is too high. And now we have a whole set of individuals in the middle that are not poor enough for legal aid and not rich enough for a private lawyer, that are essentially in this vacuum where they can't have legal representation. In Canada and the United States, access to the courts, access to justice, access to adequate legal representation, particularly in criminal matters where your life or liberty is at stake, is a constitutional guarantee that these countries are falling short on. These things are guaranteed constitutional rights. So that's a major issue, and that's one of the major arguments in favor of allowing other individuals to have training in specific limited areas, legal training in specific limited areas, to sort of be able to fill the gap that lawyers cannot fill. Sometimes it's very mundane topics, such as allowing realtors to prepare documents related to a realty sale instead of having to hire a lawyer for that. And in other instances, it could be something more complicated, like a family law matter. We've empowered religious leaders with the legal authority to sign a marriage certificate, which gets registered with the secular state system. But we haven't empowered them to be able to oversee a divorce. So, these are areas that are I think very much at the forefront of the bar associations, but not at the forefront of the public thought right now. And I think in the next 10 or 15 years, we're going to start to see a lot of rules come out and a lot of changes in the ethics rules, legal ethics rules, that might expand these services, right? Lawyers, of course, have a self-interest to maintain this monopoly over legal services. But if our fees are so exorbitant and the thresholds and the reach and ability of legal aid is so limited, in my opinion, something has to be done to ensure people have, other avenues and access to justice. And there's not, for me, not one method of resolution, of legal resolution that could be employed. There's a variety of methods that could be used to solve a particular or any particular given dispute. So that is something that I'm hoping, develops in the secular legal realm over, the next 10 years or so, but is something that I see an applicability to the religious sphere for in the future. And, I do think one of the major findings of this study has been, this idea of training programs in these other areas for people that are essentially already involved in religious dispute resolution, that already have this, authority, but don't have specific training or sanction for it by the state.
Thank you. I think that being interesting to also have some staff or students from School of Law attend this seminar, just to have a comparative view with Ireland, because law system might be different to North America. Another question from Emanuela De Sondi. Please tell us about your next research project. And then a final question from Luis. Yeah.
So one of the things that I had wanted to do was, as I mentioned before, was expand the study to analysis of state law. So I have a legal background training, and now have, very gladly welcomed religious studies and anthropology and gender studies to my work. I would very much like to inquire as to the number of religious dispute resolutions that ended up in state courts, and the number of state courts that implied religious precepts in their resolution. I think that would be a very interesting analysis to engage in. So,
thank you. So, Louise Crowley, would you like to ask your question?
Sure. Hi. Thank you for that presentation. Apologies, I was late coming from another meeting. Your research is fascinating. I just wanted to comment as another family lawyer and specializing in family formations in Ireland, as well as the resolution of breakdown. And I suppose by way of question and comment, I was intrigued about a couple of things. Firstly, so Irish family law has been very reactive and very slowly reactive to social change. So I was intrigued where in one of your later comments, you spoke about willingness to engage with same-sex couples more readily than interfaith couples. In Ireland, that our modernization of our family law, recognition of families other than families based on marriage, has only been very recent. So we have been very slow and very traditional in our laws. In fact, the only family recognized in Ireland in our constitution is the family based on marriage. So I suppose I wanted to comment on perhaps how more progressive some of the religious views that you've been citing are when compared to the Irish view, which historically has been hugely influenced by Catholicism, less so in the last 20 years. I also want, I suppose by way of question, if I may, Natalie, I was wondering, is there an element of forum shopping by parties whose relationship has broken down? So might a couple prefer to avoid the traditional legal courts because of an adverse outcome that they could avoid, or at least one of the parties might like to avoid, as distinct from going through religious-based laws or processes? I would be intrigued to know if you picked up on any sort of strategic approaches that might be adopted by couples depending on their circumstances and the options that would be available to them?
Thank you. So one of the things about North America is family law is it's not at the federal level, so it's at the state level. So we get a wide variety of rules state by state. In some states, we have common law marriage. You know, if you've lived with an individual for a certain amount of time, you're considered their legal spouse. That's what we have here in Nova Scotia. So if you have lived with someone for a certain amount of time, you have the same marital dissolution rights as a couple that was formally married. In Florida, Florida does not recognize common law marriage, which is why the issue in my study was so important on state registration, because without that state registration, the state, even if you've lived with someone for 25 years as husband and wife, have referred to each other as husband and wife, have had children and grandchildren, the state of Florida doesn't consider you married. So you don't have those legal dissolution rights. So that's one of the main issues that I have come across. And one of the reasons why religious leaders have actually pushed for the registration of marriages is to avoid essentially the detrimental effects usually towards women in the dissolution process. So in terms of form shopping, there has been, I haven't seen that specifically. So from the perspective of the religious leaders, they have felt that the people that have had sort of that inclination to come to them to seek some form of dissolution, from the perspective of the religious leaders themselves, they have said that they've really felt like people have heeded their advice and their decision and not gone on to state courts. So that would be sort of an area for future research for me. You know, how many people didn't like the response of the imam or didn't like the response of the rabbi and then filed a suit in state court? You know, this is the part of the inquiry that, you know, is really missing from this research that I didn't get to. But one of the main reasons that people went to religious leaders that came up over and over and over again was cost and access. So cost, these religious leaders are free. The legal system in North America is extremely pricey. And as I mentioned before, the threshold for legal aid is extremely low. So you could be in a very low income where you can't afford rent and food, and you could still not qualify for a legal aid representation. So that's, you know, sort of a major issue. So the main issue was cost. The second issue was access. One, access in terms of language. So the immigrant community, the Muslim immigrant community in North America is a much younger community than the Jewish immigrant community in North America. This community faces a lot of language barriers, and oftentimes the religious leader has acted as a bridge to that barrier and to the integration into society as a whole. So they have played this sort of double role as how are you able to keep up with the obligations of the secular society you now live in while still fulfilling your religious obligations? So that's the bridge that the religious leader has been building between these individuals. Most of the rabbis are second and third generation immigrants in the United States. Many of the imams were first generation immigrants that were born somewhere else and then came to the United States or Canada. And many of them speak additional languages, and the communities, the way the mosques have been formed there, they have been formed around cultural communities as opposed to religious communities. So you may see you may see 5 mosques in one city, and one is predominantly Pakistani, one is predominantly Palestinian, one is, you know, Bosnian, one is et cetera, et cetera. So very much the mosques have formed around these cultural groups, and the religious leader has provided that sort of language access. The second area of access has been for women. In a lot of the dissolution cases that the religious leaders discussed with me, the women had very little access to the outside world besides coming to their religious institution for worship or other community activities. And one of the questions I asked is, you know, in the first instance, when a couple has a dispute problem, has a family problem that we would classify as family law, so an issue of marital problems where there's a separation contemplated or divorce contemplated, or they're separated already, they're not getting alimony, they're not getting some form of child support from their former spouse. Who is it that comes to your door and knocks on your door and asks you for help? And I really thought going into this inquiry, they were going to say the man comes to the door to complain. It was almost more than 90% of the time, it was the woman that was making that first knock on the door, reaching out to the religious leader, saying, I have this issue, and then the second meeting will happen with both parties present. So in terms of access and in terms of finance and language, I found that has sort of been the main reason for seeking resolution in this religious setting as opposed to state court setting, which is very difficult for a lot of people to navigate. So
could I just rounding that off then, if you don't mind?
I'm afraid we need to close.
Okay.
Yeah, because I have another class, so we can perhaps stop the recording now and thank Natalie for her wonderful presentation. And perhaps after we stop the recording, we can continue the conversation if you want. I'll need to leave now, but if